All right, so this is my bedhead. I just got up. I struggled with this securitization video I did yesterday, meaning I don't know if it came across well. I've watched it 4 times and I sort of get it, and it's sort of compact, but it's boring as hell. So I'm going to give you the 10-minute version, and maybe that's not possible with securitization. But again, securitization is the process of bundling together all these loans, receivables, student loans, personal loans that you can get online these days. This is where a bank or a funding company needs to get their debt off their bottom line so they can have better rates when they seek more money or put more money into the economy. And the actual debts that you and I sign up for end up in a bankruptcy remote trust. Here, I'm going down this boring road again. But I want you to walk away with one idea, and that is the loan that your client is being sued for, whether it's from a debt buyer or the actual original creditor. Again, the original creditor is the originator of the loan that you signed up for, the original creditor. If you're being sued by either of those, a DNF Associates, a Midland Credit Management, a Portfolio Recovery Associates, Crown Asset, they're all carrying unassigned debt minimally, and you can get your client out of that debt. But one level further is this concept of securitization, which I use. Hear this. I weaponize credit card lawsuits now with securitization. I weaponize it. And the way I do this, I'm going to try and do it in 10 minutes. Let me read for you a deposition I just took of a witness about securitization. It was against Velocity, and they claim to have purchased an Upstart Network Inc. debt. First of all, in Velocity cases with Upstart Network Inc., they claim Upstart Network is the original creditor, the originator. But if you look at the loans, the originator is a bank called Cross River Bank. If you push them on that, they will identify and produce something that's never happened before in my 30 years of doing this. And is appropriately, because of the time of the 21st century, they now claim that Cross River Bank, or the originator, is just part of some AI platform. So I want you to look out for this new defense about an AI platform. So if you're representing clients that have these personal loans from online companies or banks, they will claim an AI platform means that the originator really doesn't exist and there's a funding source behind that. So they're introducing securitization in a way that benefits them without saying the debt was securitized, but it's funded by securitized money. And they are now seeking, this is the beginning. As you know, all my debt cases, so if you went to my video on how to defend against a collection lawsuit, or how to prevent or work against garnishments or judgments, or how to handle student loans, it's all really the concept of where is an assignment that produces the debt that places your client in jeopardy. That's a real problem because they are purchasing, as you know, in most of my videos, I use the concept of pennies on the dollar. So these debt buying companies are purchasing debt for pennies on the dollar, and they're not getting the proper paperwork. And most importantly, they can't prove an assignment from the original creditor all the way 5 steps down the road to the company that's suing you. That's a real problem for them because I operate in the 1 of 10. Remember, 9 of 10 theory is they don't care to add the right paperwork to their lawsuits because approximately 90% of their cases are going to get defaulted, or they're going to come to some harsh settlement with the client before it gets really deep in the litigation. So I operate in the 10%. Well, I think what I'm doing is expanding into their consciousness, because now their whole monkey wrench, or as they say in England, a spanner in the works. When you say you want to interrupt a process or a system, you throw a spanner in the works. This proof of assignment is getting stronger, and I'm doing it every day. And I think they're seeking to eliminate the assignment issue by saying everything now is being funded by an artificial intelligence source, and they can move around the banking sponsorship or criteria such that the judge is just going to go, look, why doesn't he pay the debt? It's, both sides muddy the waters. Anyway, so in this deposition of Upstart, their deponent is saying, and finally admitting that a trust is the source behind a debt, which is rare too. And so I ask the deponent, well, isn't that different from the original creditor, the trust different from the original creditor's name, and it's a separate entity? And it's an important distinction in the lawsuit that favors my client. And their definition or response is, yeah, but that's a funding source. Like, I should know what that means, and that means that vitiates any responsibility of them to prove ownership. Where I'm going with that is there's a creeping acknowledgement in these cases now, if you push, of securitization with words like funding source or AI platform of funding. So you can run away from securitization, and especially when I'm boring the hell out of you and trying to encapsulate this in 10 minutes, we're already at 6. There are two kinds of securitizations. There's the securitization of bundling loans together in what's called asset-backed securities. And those loans are credit card receivables or personal loans, car loans, and mortgage-backed securities. That was the cause of great crisis in this country. The debt collection buyers, funding sources, are all now using this same concept. So we've got to get ahead of that and weaponize our responses in these cases. The premise behind my 40-minute video yesterday, or whenever it was, that caused me to wake up and do this video, I don't know if I was clear about this, but we're weaponizing our responses and making credit card lawsuits for the first time just like debt buying lawsuits. So the other kind of securitization, and it's not a different kind, it's just a sort of unusual mechanism. Student loans are securitized, especially the private ones. That's the whole funding source of student loans. Where's the money coming from that they're lending these private loans? Around 2005, 2006, there was this big move by a couple of banks to put tons of money into students and then securitize the debt. No one knew or cared. 10 years later, no payments made. They're coming after my clients with companies included in their names 2005-1, 2006-1, NCSLT. Those are called slabs. Those are student loan asset-backed securities. So you have the asset-backed security, securitization trust, and the slabs, the student loan asset-backed security. The distinction with those student loans is they're really easy to get your client out of on a private student loan. However, I stay away from, and I've taken classes to get better at this, but it's tough. The federal government, which Biden just gave students massive forbearance, and now as of September, students will start having to pay these loans back, interest-free, hopefully. That's going to produce a lot of litigation because these banks will somehow worm their way into putting the interest in there anyway. But I can't help clients that have federal student loans, and they're the most tragically victimized and abused. I can't do anything. However, there's a little window here. Student loan debt is securitized. Even on a federal level, they've stopped doing it as much as they used to. I think Navient is the biggest one. But if you've got a student loan client that has old student loans that are federalized, they're federal loans, you can't even bankrupt those loans. There's a specific statute that says you can't do that in the bankruptcy code. But if they're securitized, they're no longer owned by the people, Navient, that are coming after you. Navient makes a ton of money from securitizing stuff. In other words, again, conceptually, securitization is the change of ownership. And you have to show an assignment for both the trust to have it, and when the original creditor sues you, they've got to show an assignment back from the trust. So I want to weaponize briefly in this, hopefully 10 minutes. It's already 10 minutes. Hope it doesn't go to 40. But one of the things I advise you to do, and you should do this. Go to sec.org. Oh, I got to say this. This video is done under the auspices of entertaining, informative, educational views of my own that you can use in your own state. And I'm not practicing in your state. You're not my client. But I hope this loosens the lid for you so you can turn it all away. Go to sec.gov and just punch in any original creditor. It's Synchrony, Bank of America, Citigroup, which is Citibank. As I said yesterday, if Citigroup is securitizing your debt and Citibank is the plaintiff, there's an issue there. How did Citigroup get your debt? And is there an assignment back and forth? The assignment is everything, and I think the debt buying world is getting that. Again, be on the lookout for an AI-influenced foundation of ownership now, where it's just going to be a wink and a prayer. And judge, don't worry about it. It's AI. Sometimes saying words or letters alleviates you of any desire to prove anything. And that's the world we live in. We're in an AI world. So go to Synchrony, Bank of America, Citigroup, whoever it is that's suing your client, JP Morgan, and put in Google or sec.gov and just say financial reports. And let's say they're alleging that your client took out the loan, usually without any proof, in 2017. Just go Bank of America, financial reports, 2017. And boom, up will pop Bank of America's required financial report to its stockholders, telling you why we're going to have a banner year, why we made money, why we didn't make money, what we're doing. And Control F, securitize or securite. Just don't eliminate the possibility of derivatives of securitization, securitized, securities. And you will see securitization so prevalent in their financial reports. And they all say the same thing. For example, Citi says the corporation securitizes originated and purchased credit card loans. There you go, right in their financial report. Another one says the card business securitized both originated and purchased credit card loans primarily through the Chase Issuance Trust, the trust. They're just telling you, hello, it's right in front of you. Another major creditor says the company primarily securitized credit card receivables and mortgages. Other types of securitized assets include corporate debt instruments in cash and synthetic form, whatever that means. So their own paperwork, they are mandated to provide their shareholders where they're getting money from, where the profits are coming, but they're also required to tell their shareholders possibilities down the road that's going to impact the bottom line, good or bad. And securitization is a form of income. It's also a form of risk, because if you are taking these bonds from these securitized trusts and the economy goes down and everything starts defaulting, you're not getting the rewards that you signed up for. So they have to alert their shareholders about this, that they securitize a lot of stuff for the purposes. One of the purposes is income to help with the stock, and they have to tell the truth. Just go to their financial reports. It's right in front of you. So sec.gov, or just go Bank of America, financial reports, 2017 in Google. You'll get everything you need. If you examine the trust paperwork, it'll literally tell you that the person suing you doesn't own the debt. For example, NCSLT has in their pooling and service agreements and their sale documents a section, Article 12, titled Assignment. The seller hereby assigns his entire right and title interest as purchaser under the sale agreement and student loan purchase agreement. I'm reading this. There's a point. Thereunto the purchaser of, as of the date hereof, it acknowledges that the purchaser will assign the same together with the right, title, and interest of the purchaser hereunder. Here he goes. To the indenture trustee under the indenture. So that small paragraph is telling you it's in a trust. We've sold it to the trust. So when we sue you, we have no rights, title, or interest because we gave it to an indenture trustee. Look that up. I'm just going to take 15 minutes just to explain that. But it means NCSLT is suing you wrongfully. NCSLT has a number of companies that are selling at the debt. The National Collegiate Student Loan Trust, the National Collegiate Funding, LLC, First Marblehead Corporation. There are all these entities that are all behind every debt collection lawsuits. And they are your friend in that you have to have an assignment and showing of the right, title, and interest passed to each entity. And the chain, the link in the chain is always missing. And the chain is only as strong as its weakest link, or in this case, the missing assignment. So when I talk about the weaponization by securitization, I'm going to tell you something really cool right now. All your discovery is now changed. You should include in your witness lists, I'd like to talk to the indenture trustee, the custodian of the records of the trust, all the trust entities. Please tell me the name of the person that is in charge of administering, or company, but they need a custodian of records. Include that in your discovery request. Your exhibit lists should mention the trusts, the secured trusts. Your affirmative defenses should say, this is in a secure trust, therefore they're suing me improperly. That's a pleading. By the way, affirmative defenses are pleadings, just like a complaint is a pleading. You're making an allegation. And by the way, if you don't make the allegation, you lose it. So put it in there about the secured trust. Your witness list says, we want to talk to the person in charge of the secured trust that held the debt, when, why, where, how. Your deposition notices, if you go look on collectionstopper.com, I've got deposition notices. They all talk about the secured trust. See how this stuff weaponizes the ability to get into their underwear, actually, just to go deep and find out what is going on. So you take a simple credit card case that your client's going to go, yeah, I owe it. Can you get me a deal? And you weaponize this with securitization where they're having to pay you better than when you have a debt buying case. If you do this right, weaponize. Most of this stuff, if it's under 10 grand, the law firm or the creditor is not going to want to deal with this because the ramifications are not good for them if this gets out. So when you weaponize even the affidavit, most lawsuits have an affidavit, like Bank of America and American Express, just slap on the same affidavit from the same person saying, yeah, the client did this in 2017, they owe this because we say so. I've looked over the personal records, I'm assigned to do this. But they mention nothing about the fact that the debt was securitized. Case over. They just lied. If you don't include the securitization process that their own paperwork says, their own financial reports says, we securitize debts. even if their response to that is, we didn't securitize this debt, that's not going to be true either, because you can't just reach out and go, was this debt secure? There's millions of these things. They're all securitized. That would be a weak link in the securitization process if they could look at one debt not being securitized amongst all of them. It's just a process, an automatic process of securitization that they cannot deny. So any affidavit you get now, having your affirmative defenses, the affidavit is a violation of, depending on what state you're in Michigan it would be MRE 8036, business records exception. But in your state, whether it's federal or state, it's going to be an 8036 designation. Include that in your affirmative defenses. Include it in your counterclaim. Citibank has sued me. They shouldn't have sued me because they don't own the debt. That's a violation of the FDCPA. As I spoke in the 50-minute version or 40-minute version, I turned them into debt collectors using their own words. So again, weaponize the litigation process with this securitization. Weaponize and securitize. Securitize and weaponize. You can weaponize with their securitize. Whatever sticks to your freaking brain, use this. It's very simple to go Google this and weaponize how you handle these cases. Even when you're deposing them, if this person is a custodian of records of the file that's going to come in against your client, when was this debt securitized? They will not know. They barely know their own job, most of these deponents that are head of the corporations that are suing you or you're suing them. They look at you like a deer in the headlights. I'm getting more deer in the headlights from deponents these days. It's like asking them to spell securitization. They don't know. They never heard of it. So you can actually take their sales documents and go, well, who is this trust? MPLI Holdings Trust National 2019. The minute they say, I don't know, you just won that case because it's in their paperwork. I think you're going to force the industry to be more educated the more you force this. It's just going to upset debt collection. I think we are looking at the end of the model of debt collection today. And I think, as I said at the beginning of this video, the debt collection industry recognizes that and is going into this AI format. So while we can, and we can for at least a couple of years, weaponize your responses or your counterclaims or lawsuits. I'm suing this company today, I hope, a creditor, for suing my client, even though they clearly signed up, my client signed up with this company, but they didn't, they sued my client and they admitted they securitized the thing. So they should never have sued my client, but they wouldn't admit that without me pushing. That case will get settled. So the weaponization of your practice starts today. Use this securitization approach. Just spend 15 minutes lifting those heavy weights for a couple of days, and then you will have a new weapon. I want to thank you. This is supposed to be the 10-minute version. It's 23-minute version, but maybe you put the two together. Check out my debt collection lawsuit video or how to handle debt collectors videos. Most of my videos might make more sense now as far as my touching upon securitization, but not going into it in those videos. Now I am. Please go to collectionstopper.com and everything I just talked about in paper form, in templates that you can use to conform to your own state's or jurisdiction's requirements is there for you. Securitization is a national process. There's only one form of securitization, whatever state you're in. Use it. Weaponize your practice. Weaponize the litigation. Weaponize your responses. Also, look for the debt collection or the creditor's responses to your hard work. please use that unique brain you have to weaponize how you handle these cases, and then filter and look at how they respond to you. The responses are everything. As I was doing yesterday's video, I thought about this, but I didn't say it. Imagine, if you will, an American submarine underwater, and it senses there's a Russian sub out there. So what it does, and in fact, cell phone technology works like this too. It sends out a ping, and the ping goes out, and if there's not too much sophistication in the Russian sub's ability to hide from the ping will tell the American sub exactly what's out there. Is it a whale? Is it a school of fish? Or is it a Russian C-class sub? And that's what you are doing when you use securitization. You're pinging out there to see what comes back, dude. Use your brain. Send the securitization ping. See what comes back. Then weaponize how you litigate. Securitization is a new weaponization and a new practice and a new way of helping people and a way to make all debt litigation as simple as suing or defending against debt buyers, because you are dealing with assignments and debt buying, whether it's creditors or whether it's debt buyers. Securitize, weaponize. I thank you for watching. I'm sorry this didn't go 10 minutes. It's supposed to be the short version. I literally got up with the bedhead. I literally got up and did this video. Hope I look okay. I didn't even look. So I got my messy house because we're all renovating. There's contractors here. Collectionstopper.com for everything you need to do what I just talked about. Use it. Learn from it. It's all free. And please contact me if you need more. For my podcast listeners, I point my finger to the temple and go, I got 30 years in here. Please, I can give you 30 minutes on any subject from this head of 30 years of nonsense. But weaponize your practice. Thank you very much. Have a good day.